Yes, good morning, Mr. Wright.
Good morning, my lords, my lady. I appear for the appellant, the entry clearance officer this morning. My learned friend, Mr. Jaffrji, appears for the respondent, Mr. Spence, with Mr. Barochwala. Lords, my lady, Mr. Spence, the respondent, as the court knows, is a sex offender from Jamaica. He has been sexually attracted to children. In 2007, when he was 23 years old, he commenced a sexual relationship with a 15-year-old British citizen who was on holiday in Jamaica with her parents. That child, who is now an adult, is Mr. Spence's wife, and they have a daughter. In 2009, when Mr. Spence was 25 years old and was in the USA, he was convicted of lewd and lascivious behavior with a minor and was sentenced to 3 years in custody. He was subsequently deported from the USA to Jamaica, and he now seeks to come to the UK as spouse of a British citizen. The Secretary of State takes the view that his exclusion from the UK is conducive to the public good and that his conduct makes it undesirable for him to be given entry clearance. On appeal, the First-Tier Tribunal disagreed with the Secretary of State's view and held that it would not be conducive to the public good to exclude him from the UK. The Upper Tribunal upheld the First-Tier Tribunal's decision, and this is a second appeal from that decision.
Can I just ask you this, Mr. Malik? Have I understood the procedural position correctly, that when this was appealed to the First-Tier Tribunal, it was under the provision of the 2002 Act, which permits there to be an appeal against a Human Rights Act decision?
Yes.
That was the only ground of appeal?
Yes. 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 So I shall seek to persuade you, my lords, my lady, that the decision of the First-Tier Tribunal, contrary to the Upper Tribunal's conclusion, is wrong in law. There are, as the court knows, 5 grounds of appeal. The first ground concerns proper approach to the words conducive to public good in paragraph S, EC 1.5 of the immigration rules. The second ground relates to the effect of the word undesirable in that rule. The third ground concerns the standard of conduct to be used in making an assessment under that rule. The fourth ground is that the First-Tier Tribunal's conclusion is inadequately reasoned or perverse. And fifth and final ground concerns engagement of Article 8. So subject to any observations, what I propose to do this morning is to address you first on law and policy as it applies to grounds 1 and 4, including the question that my Lord Justice Lewis asked yesterday by an email as to the jurisdiction, the basis on which a person brings an appeal to the First-Tier Tribunal and the role of the tribunal on an appeal.
The powers.
Once I've made submissions on law, I will then take you to the First-Tier Tribunal's decision and make submissions on the 4 grounds in turn. Ground 5 is a distinct ground, and I will address it separately at the end. And once I've addressed you on all 5 grounds, I will then make some submissions on the procedural objection raised by my learned friends, that certain points that I raised before this court were not raised by the presenting officers before the First-Tier Tribunal and the Upper Tribunal.
Thank you. Have you agreed with Mr. Jaffrji the timetable for your submissions?
I'm afraid no, my lord, but when I propose to take, we have spoken about this, I propose to take no more than 2 hours in my submissions. Right. And I suspect that my learned friend would take around 2 hours as well in his submissions, and then there would be a brief reply.
Right, thank
Law first, if you look at the authorities bundle, behind tab 3, behind tab 1, you have section 3 of the Immigration Act 1971, and under subsection 1, the Secretary of State grants leave to enter or remain to a person who is subject to immigration control. So when a person makes an application for entry clearance, that person effectively asks the Secretary of State to exercise the discretion under section 3.1, 3.1b, and to grant that person limited leave to enter. And once that person is in the UK, that person may then be granted leave to remain. As the court knows, the immigration rules are made under section 3, subsection 2, which is on the next page, page 3. My lords and my lady will know, of course, that the immigration rules are the statements of the Secretary of State's policy as to the administration of immigration control. Statements as to the practice to be followed in the administration of this Act. Subsection 5 provides that a person who is not a British citizen is liable to deportation if the Secretary of State deems his deportation to be conducive to public good. And these are the words that also appear in the rules that I will show you in due course. If a person's deportation is conducive to public good, in the Secretary of State's view, that person is liable to deportation. So this is the primary statute. Now before I show you the rules, may I respectfully take you to an authority that concerns proper approach to the reading of the rules. The court is, of course, aware of the authority. It's behind tab 8, the judgment of the Supreme Court in Mahad. The paragraph that is relevant is to the grounds is paragraph 10. You have that paragraph at page 139. My lords and my lady will see that Lord Brown adopted what was said by Lord Hoffman in MO. Construction of a rule depends upon the language of the rule construed against the relevant background. Lord Hoffman also explained what that background entails. That involves consideration of the immigration rules as a whole and the function that they serve in the administration of immigration policy. So a reading of a rule that is not consistent with the immigration rules read as a whole would not be an accurate construction. If you then look at the remaining part of that paragraph, which is at page 140, between letters B and C, you'll see that the rules are not to be construed with all the strictness applicable to construction of a statute or a statutory instrument, but sensibly. So construction of a rule must be sensible. And the ultimate question, this is against letter C, is what the Secretary of State intended his policy to be. So when the court is facing with a question as to the construction of a rule, that is the question that the court will ask.
Well, not quite. It's not what he or she thinks is a good idea. It must be taken to have intended. It's an objective process of what you work out him to or her to have intended from the words used, read in the way that you just said.
Yes. No issue with that, my lord. The court's task is to decide what the Secretary of State intended the policy to be, And of course, my lord, I completely accept the point that that is to be discovered by the words used in
Very
the
context.
Absolutely. Now, with that in mind, if I may then show you the relevant rules, they are behind tab 2. Now, Appendix FM is an extensive appendix to the immigration rules. It wasn't sort of practically possible to copy the entire appendix here. So what I've done is that I've simply taken the relevant rules. Now, paragraph Gen 1.1 may answer or may assist the court in relation to the question, my lord, that my Lord Justice Lewis asked yesterday. So if you look at that paragraph, that sets out the purpose of Appendix FM. So Appendix FM was introduced in 2012 to reflect the Secretary of State's policy towards Article 8. And you'll see that this is the route for those seeking to enter or remain in the UK on the basis of their family life with a British citizen. If you then look towards the end of that paragraph, you'll see that the purpose is that the appendix sets out the requirements to be met, and it reflects how, under Article 8, the balance will be struck between the rights to respect for private and family life and the legitimate aims of protecting national security, public safety, and the economic well-being of the UK. So true it is, my lords, my lady, that an appeal to the First-Tier Tribunal is available only on public law grounds. The question of public interest is to be judged by reference to the Secretary of State's policy as set out in the immigration.
Sorry, I thought it was on human rights grounds, not public law grounds.
No. My apologies, indeed, yes. So the appeal is available only on human rights grounds. But the question of public interest is to be judged by reference to the Secretary of State's policy as set out in the immigration rules. So these are the rules that, in the Secretary of State's view, strike the balance between private interests and the interests of the economic well-being of the UK and public safety. So if a person meets the requirements of these rules, provided that Article 8 is engaged, the tribunal will allow the appeal on Article 8 grounds.
Well, that's a very big sentence, if meets the requirements. That depends what that means. I mean, some may be questions of fact. Is the father of a child who's British? Mm-hmm. DNA, birth certificate, you know. What about the question that's at the heart of this case, whether or not something is conducive to the public good? The fact they're not in dispute, 2 relationships with underage children, and downplayed it in interview. And the question then is, who decides whether or not that is or isn't conducive on a human rights appeal? Is it the FTT or the Secretary of State? That's the issue, which we've dodged so far.
Yes, yes. Now I have taken instructions that on this. That the position is that it is the tribunal that makes the decision,
giving appropriate weight to the judgment of the Secretary of State.
Yes.
Correct me if I'm wrong. Speaking of myself, I don't think there's any great mystery or special legal regime which applies to immigration cases. Yeah. This is generally the task of courts and tribunals when they're faced with an allegation that there's been a breach or will be a breach of Section 6 of the Human Rights Act. And there's lots of learning now over 25 years.
Yes.
On what the approach is. The court or tribunal has to decide the question of proportionality. But it doesn't do it with a blank slate. It must also give appropriate weight to the assessments made by, in this case, the executive. Sometimes it can be the legislature.
Yes. But it is. I accept. It is for the tribunal to make its own decision, as long as.
Well, when you say make its own decision, again, we need to be careful about what that means. Clearly, it has to take a decision as to whether the refusal of entry clearance is a breach of Article 8. does it have to decide as a matter of discretion whether refusal is or is not conducive to the public good?
May I
come back to that, actually,
yes,
but that's a key issue.
show you the relevant. There is. I mean, I hope I know from where the confusion arose. There are references to exercise of discretion in the decisions made below. Yeah. But when you will look at the rules, you will see that there is no discretion here.
No discretion. Other than the general discretion which you've just shown us to grant or refuse leave to enter.
Yes.
In the 1971 Act.
Yes. So if you look at page 8 of the bundle, so I've shown you the purpose. If you look at paragraph SEC 1.1,
yes,
the applicant will be refused. There is no discretion. Will be refused. Where the rule applies, an application for entry clearance must be refused. Now, there are other provisions in the rules that use the word may. There are provisions that are discretionary, provide that an application may be refused if certain circumstances arose. But we are not in that territory. It's common ground that the rule is mandatory. Where it applies, the application must be refused. If you look at the next page, you will see that the rule then sets out circumstances in which it applies, and you'll see that paragraph 1.4 provides that exclusion of the applicant from the UK is conducive to public good because they have, and then there are criminality grounds. But the paragraph that we are concerned with,
and dealing with those is if there'd been a factual error, they thought the sentence was 4 years, but it was actually 2 years.
Yes.
Then that would be fine. They'd have to take that decision and say the rules are not applicable, and therefore relying on the rules wouldn't be a proportionate exercise. But that's not this case.
Yeah. So this case is about 1.5. The exclusion of the applicant from the UK is conducive to public good because of the applicant's for example, the applicant's conduct, including convictions which do not fall within paragraph above, ... make it undesirable to grant them entry clearance.
That's not an automatic rule. Somebody must decide whether it's undesirable. And the question is who?
Yes. So there has never been an issue as in my submission as to who decides. It's in my submission fairly well settled that on an appeal it's the judge, it's the first-tier tribunal that decides whether a person's conduct is such that it would be undesirable for him to be given entry clearance. So it is the judge who makes that decision, bearing in mind, of course, the principle of deference attaching due weight to the Secretary of State's assessment.
So it's not for the tribunal to say, well, the Secretary of State has decided that it's undesirable. The reasons are obvious: too sexual involvement with an underage child, and the question for the tribunal is whether it's disproportionate given the other factors to do with the child and the mother as to deciding compatibility. The starting point is they decide as a matter of discretion whether or not it's conducive to the public good to exclude him.
No, the tribunal conducts an assessment. In my submission, the tribunal conducts an assessment of whether a person's exclusion, or if the person is in the UK, his deportation.
Yeah, but stick with the fact, exclusion. It's the decision-making process that I'm interested in, that you say the first-tier tribunal judge must go through.
Yes, so it is. The Secretary of State has made the primary decision. On appeal, it is the task of the judge to decide for themselves as to whether the decision is unlawful under Section 6. And that requires the judge to decide for themselves as to whether this rule applies, whether a person's exclusion from the UK is or is not conducive to public good. But in making that decision, the judge will attach due weight to the Secretary of State's assessment.
But is that right? Because if the appeal is a human rights appeal, at first blush it would seem to me that the question for the tribunal is whether the decision is disproportionate. When you balance on the one hand, just oversimplifying slightly, the public interest in firm immigration control, and on the other hand, the Article 8 considerations that are raised on the facts. And it just strikes me that requiring the FTT or enabling the FTT to make an assessment of conduciveness to the public good is likely to be a distraction, because that question only deals with one half of the assessment that's required when a human rights claim is refused. Do you understand? I mean, it's a rather wordy question, but do you understand the point I'm making?
Yes. So where the Secretary of State has made a decision that paragraph 1.5 applies because it is conducive to the public good to exclude an appellant. That appellant and all other requirements are met. That appellant brings an appeal to the tribunal and provides evidence seeking to impugn, undermine the Secretary of State's assessment. He says that, well, my conduct is not such as it would make undesirable for me to be given entry clearance. Yes, I have a conviction or I've done something wrong, but there is further evidence of the sort of positive features of my character. The judge looks at all the circumstances. The judge makes a decision whether or not this rule applies.
It's the word applies. The rule clearly applies in the sense of it is a rule that is applicable.
Yeah.
The question is who decides, firstly, what is undesirable if there's convictions, and then secondly, because it's going to be the Secretary of State first off, what the role of the tribunal is. And you seem to be saying that this discretion, because it's a discretion, not an application. It's not like did he commit the criminal offence? Has there been an error of fact? Or is he actually subject to a deportation order? Those are factual questions. And if those factual questions are wrong, you can see that feeds into the disproportionality. But when it's a balancing exercise, the Secretary of State is responsible for immigration control, and they say, this man has gone with 2 underage children. I don't think he should be allowed to come in. I think that isn't conducive to the public good. It's undesirable. You're saying that doesn't matter. The discretion of the FTT, yes, he must give what you say is due weight to it. What that is an interesting question. But the exercise of any discretion under the rules, once you raise an Article 8 point, is a matter, first off, for the tribunal to decide. Seems to be what you say the Secretary of State thinks.
Well, this is how the tribunals have been making decisions for years and years and years, and this is how this court have approached these issues.
Well, you'll show us the authority that says that in due course.
I mean, there isn't, I'm afraid, an authority that expressly says that, well, it is the task of the tribunal to make an assessment under paragraph 1.5.
It's not an assessment, it's an exercise of discretion.
Well, it's an exercise of discretion or an evaluation.
Yes,
I mean, it's an evaluation of whether or not exclusion is conducive to the public good, and if the outcome of that evaluation is it's not conducive to the public good to admit the person, well, then there's a mandatory rule that says you've got to refuse entry clearance.
So this is not a unique rule as such. I'm sure Lord Justice Singh may recall a case called Balaji Gari that was decided many years ago. That concerned paragraph 3225 of the immigration rules, which is equivalent to paragraph 1.5 and relates to someone who is already in the UK. That rule allows the Secretary of State to refuse an application for leave to remain on character and conduct grounds, saying that it would be undesirable for an applicant in the light of what that person has done previously for him.
But I thought the argument there was that he hadn't done it.
Yeah, I don't. Speaking for myself, I think we should focus on human rights. That's why I started by asking, what's the only ground of appeal?
Yes.
Human rights. And speaking for myself, it seems to me that the correct analysis is that the task of the tribunal is to decide whether there has been or will be a breach of Section 6, subsection 1 of the Human Rights Act.
Yes.
Which talks in terms of incompatibility with a convention right. But it is unlawful for a public authority, here the Secretary of State, to act in a way which is or will be a violation of a convention right. And in deciding whether it is a violation or will be, the tribunal's task is to decide the question of proportionality, which means weighing up various things. As my lady has said, it's a balancing exercise. Now, the rule may overlap with that question, but it's not exhaustive of that question, because she says whether something is conducive to the public good may well go on one side of the balance, but that's not the end of the inquiry as far as proportionality is concerned. On the other hand, you're perfectly entitled to say that the tribunal isn't responsible for immigration policy and control in this country. The Secretary of State is, and so the tribunal should give due weight, maybe a lot of weight. We can debate that, but it seems to me that there's a real danger of creating mystification in different areas of the law. Well, the Human Rights Act applies in the same way, right across the whole scope of public decision-making. And there's been lots of authority about this, what the task of a first instance tribunal is, or a court. The Supreme Court has talked about this in Schwedler, which isn't an immigration case, but that doesn't mean that it's not relevant. That's correct me if I'm wrong, but that's how I see what this is all about. And speaking for myself, I'm perfectly content to accept that this rule isn't creating a discretion. The discretion is in Section 3 of the Immigration Act, 1971. This does call for an evaluation or an assessment. Fine. But this isn't the end of the inquiry either. Because even if the Secretary of State perfectly lawfully, in public law terms, perfectly lawfully applies her own immigration rules, that's not the end of the inquiry under the Human Rights Act, because there may still be a breach of the Human Rights Act. The question is there?
Yes, I mean, I do not disagree at all with a lot of what you have said.
Okay. Well, we've interrupted the flow of your submissions. You've got a lot to cover.
Yes.
So please do continue.
I mean, in the supplementary authorities bundle, you have a couple of authorities that may assist you on that. I mean, they do not sort of expressly say that an assessment under 1.5 would be an assessment for the judge, but the broad point is that well, it was always sort of accepted.
So where do you want us to look now?
Perhaps if I may just show you an authority in the main authorities bundle and then one in the supplementary bundle. My apologies. So behind tab 15 of the bundle, you have the judgment of this court in TZ Pakistan. So TZ Pakistan is a case where which concerns Appendix FM to the immigration rules. There is a provision in the immigration rules in Appendix FM which says that if a person has no leave to enter or remain in the UK, and if that person is in a relationship with a British citizen, then that person has to meet the test of insurmountable obstacles before the person qualifies for leave to remain on Article 8 grounds.
Yes.
And may I ask you to look at paragraph 34 of the judgment, which is at page 288. So the question as to whether there are insurmountable obstacles is a question of evaluation, is a question of judgment. and you'll see that the court said that the tribunal should undertake an evaluation of insurmountable obstacles test for itself, and then says at the end that the benefit essentially is that if a person satisfies the rules, where a judge has evaluated the facts and decided that there are insurmountable obstacles, the requirements of the rules are met, then that will be positively determinative of the person's Article 8 rights, provided that their case engages Article 8.1.
Yeah. Well, that's fine, because in a sense it's a benevolent provision. So if you comply with the rules, that ends the inquiry. But this is recognising that that may not be exhaustive of what Article 8 requires.
Yes, of course.
Yes. That's one point. But the second point is that it may depend on what the terms of the relevant rule are. And again, I think there's a real danger of over-mystifying all of this. But in the rule was presumably framed in terms of insurmountable obstacles, and one is familiar with that concept. There's case law from Strasbourg, which is the origin of all of that. But here, is your submission that the only question for the tribunal is whether the relevant provision in 1.5 that we were just looking at is satisfied, one way or the other?
No.
No, you're not saying that.
No.
Fine. Then there's no real mystery about this. It can help you. It can help. When I say you, it can help the respondent.
Of course, yes.
If, for example, the tribunal thinks that it's not conducive, or the rule is not made out. But what if it thinks that it is not conducive to the public good, in principle, but there's such a heavy impact on, for example, the welfare of a young child, that when it conducts the Article 8 balancing exercise, that outweighs the public interest expressed in the rules? What does the tribunal then do?
The tribunal would allow the appeal.
Yeah. That's what I thought.
No issue with that.
Yeah. Thank you. Right. So that's TZ.
That's TZ. In the supplementary authorities bundle, page 68, you have the judgment of this court in a case called Yassin. This is where the judgment of this court in Balajikari was applied in the context of a human rights appeal. So Mr. Yassin made an application to the Secretary of State on long residence grounds. There was discrepancy in the figures that he provided to HMRC and the figures that he provided to the Secretary of State in seeking leave to remain. The Secretary of State held that his conduct was such that it was undesirable for him to be given leave to remain.
When you say conduct, because the Secretary of State thought it was deliberate, or because the Secretary of State didn't care whether it was deliberate or accidental, or does it not matter?
Now, the Secretary of State took the view that it was deliberate, and the appellant accepted the finding that there was a discrepancy, and that he failed, therefore, in the sense that the rule applied in principle. But the tribunal in that case had not conducted a balancing exercise. The tribunal took the view that the rule had applied, and that was the end of the matter.
Was this an Article 8 case?
That was an Article 8 case,
Right.
yes. Right. And if you look at paragraph 46, this perhaps is the point that my Lord Justice Singh was seeking to was making, that well, even where the rule in principle applies, there is still a room for balancing exercise. And what the court said was that unless the case is so clear, a balancing exercise is nevertheless required.
It's just so much turns on the details, and we're skimming through it, and you've got a lot to cover. But without knowing a lot more about this case, I don't know how that paragraph helps.
No,
because I don't know whether there was a finding of fact that the Secretary of State was wrong and it wasn't deliberate. And if it wasn't deliberate, that might be clearly relevant to the question of proportionality. If it was deliberate and the Secretary of State said, I do not think somebody who deliberately misrepresents their figures to the tax authorities should be allowed to remain here, whether this case says, oh, but that's not for the Secretary of State ultimately to decide, it's for the tribunal to decide whether a deliberate deception is causes the rules to be satisfied or not satisfied. That's the issue here. It's not applied, it's satisfying. Who takes the primary decision of satisfaction of the rules? And what is the road of the FTT? Does it just start again? Or is it a more nuanced, complex position? That's what troubles us, I think.
No, I completely understand the point. It's just that this isn't, strictly speaking, an issue between the parties in this case. And I understand the point that is troubling you, my lord, but for the last 20-odd years, the tribunals have been making these assessments, proceeding on the basis that it is for them to make their own decisions as to whether or not a rule applies, to conduct the balancing exercise.
The rule is satisfied is what you really mean, not applies. The rule clearly applies in the sense you've got to decide whether or not it's met.
Yeah, whether it
The
is.
decision on satisfaction on what is conduct conducive, not conducive to the public good, is ultimately for the tribunal, taking account of the Secretary of State's view.
Well, this is what the tribunals have been doing for years.
And that's what the tribunal did here, you say?
Yes. I mean, when I said I do not disagree with respect with what my Lord Justice Singh said. But if the point is really troubling you, then may I respectfully suggest that this perhaps is not the case to resolve the point. I mean, of course, this isn't a ground of appeal that was taken from the First-Tier Tribunal to the Upper Tribunal. This isn't a ground of appeal that the Secretary of State takes before you.
Well, you've got a lot to cover,
Yes.
so I suggest that you make the submissions that you were intending to make.
Yes. So, Lord, I was showing you the relevant immigration rules, tab 2,
Yes.
page 9. So the submission that I make is twofold. The first is that in deciding whether a person's exclusion is conducive to the public good, the decision maker is obliged to have regard to the immigration rules as a whole and the policy that they serve. Secondly, when making the assessment of whether a person's presence would be undesirable, then the focus ought not to be, in my respectful submission, on the threat posed by that person or the risk of reoffending. The matters that are relevant in my submission would include, in a case of this sort, the need to mark public revulsion at the offender's conduct and deterrence to others. So those are, in my respectful submission, relevant considerations. So if the fact finder, the judicial fact finder, fails to have regard to the immigration rules as a whole, and fails to take into account these two matters, public revulsion and deterrence, then in my respectful submission, that would amount to an error of law.
Suppose you're right about those points. What would follow on your submission? Remittal?
Yes.
To the FTT?
To either the First-Tier Tribunal or the Upper Tribunal.
I see.
You'll hear submissions from a learned friend, and of course, if once you have heard submissions, once you have looked at the evidence and the findings made below, if you take the view that there is no room for a different outcome, it is clear that the rule is satisfied. Then of course, subject to what my learned friend says, it would be open in principle to the court to substitute a decision. Dismissing the appeal. So immediately after that, what I've done, my lords, my ladies, that I've quoted the rules that are now in place with effect from 11th of November 2025. And my lords and my lady, you'll see that what was section SEC 1.5 is now SUI 3.1. There is now, which is at page 10. So there is now a separate appendix called part suitability, and that sets out all suitability grounds.
Right.
Now, if you then, my lords, go to tab 3 of the authorities bundle, you'll see immigration rules relating to deportation. And my lord will see from the second paragraph at page 12 that a deportation order is made on the ground that deportation of a person is conducive to public good. That is the same phrase as it used in section 3 subsection 5 of the 1971 Act and the immigration rules. And you'll also see from the fourth paragraph that if a deportation order is made, then that invalidates a person's permission to enter or stay in the UK. When is it that a person becomes liable to deportation is set out at paragraph 13.1.1, right at the end of page 12. A person is liable to deportation where they have been convicted of a criminal offence. That would include offences in the UK or outside the UK, for which they have received a custodial sentence of at least 12 months. So the rules say that if a person receives a sentence of 12 months, whether in the USA or the UK, that person is liable to deportation. And that becomes clear when one looks at paragraph 13.2.1, which is at page 13. Where a foreign national has been convicted in the UK or overseas and received a custodial sentence of at least 12 months, then the public interest would require that person's deportation unless the exceptions apply, and none of those exceptions apply in this case. What that means, my lord, is that if this person is granted entry clearance, he comes to the UK, on arrival, he will be liable to deportation.
Well, liable to deportation doesn't mean must be deported, no matter what the consequences for example, the child. Surely.
So,
if otherwise, let's assume a scenario where there would otherwise be a breach of the Human Rights Act. Mm-hmm. Are you saying that because somebody's liable to deportation, that means that that's the end of the inquiry?
No, I'm not saying that. So if you look at 13.2.1, so it's not simply that a person becomes liable to deportation.
Yeah.
13.2.1 says that if a person has been convicted in the UK or overseas, it has been sentenced to 12 months, then public interest would require that person's deportation.
Yes.
Unless the exceptions apply. And one of the exceptions, of course, relate to the partner. One exception relates to the child. if the consequences of deportation would be unduly harsh on the child or the partner, then the public interest would not require the person's deportation. The point is that none of these exceptions apply in this case. So no one is suggesting that relocation of the partner or the child to Jamaica would have unduly harsh consequences. And therefore, as soon as this person comes to the UK, the public interest would require his deportation.
Well, the problem is we don't get to deportation yet. We're looking at the rules, and rightly or wrongly, you've got 3.4, is it, and 3.5 are separate. And you've decided only to make it absolute for certain convictions, and they don't match the convictions for deportation. But that was your choice.
Yeah. I mean, one reason that could explain is the fact that there is already a rule that says that an application for entry clearance must be refused if the exclusion is conducive to public good. And it may be that it was felt that that was enough to ensure that a person whose deportation is conducive to public good, if that person were in the UK, is not able to get entry clearance to come.
I don't understand that, though, because you've got SEC 1.4. The exclusion of the applicant from the United Kingdom is conducive to the public good because they have, A, been convicted of an offence for which the period is, etc., etc. So in the entry clearance rules, which you've shown us at page 9, the Secretary of State has carefully calibrated those offences which must lead to refusal.
Yes.
And then there's a catch-all. So how can we interpret the catch-all by reference to a different set of thresholds for a different decision? That's my problem with that argument. It looks odd, but that's the Secretary of State's decided to do that.
Well, the simple submission, my lord, is that in deciding whether a person's exclusion is conducive to public good, the decision maker is required to consider the immigration rules as a whole and the policy.
Including 1.4, though.
Yes.
Anyway.
Now, the point that is troubling, my lord, of course, troubled many others, and that issue has now been fixed in the sense that the new rules do not have that distinction anymore. If you look at the rules that were introduced from 11th of September last year, you'll see that distinction has now been abolished.
We're doing it for decisions after that date.
Yes.
Yes.
So that does not affect the analysis. And now behind tab 5 of the bundle, you have the Secretary of State's conducive deportation policy. And this reflects the position in the immigration rules. And if you look at page 49 of the bundle, you'll see a heading threshold for deportation. And you'll see that sort of sets out the Secretary of State's policy. And the government's policy is to pursue deportation on grounds of criminality, where the person has received a custodial sentence of 12 months or more in the UK or overseas. So if that is the government's policy, then it would be incoherent to permit a person who is outside the UK to enter the country, simply for that person to be given with a deportation decision.
But once they're in the country, wouldn't they be entitled to appeal? Because they'd be served with a notice of intention to make a deportation order, and then they'd appeal, wouldn't they?
Yes, of course, there will be an appeal.
And on the appeal, they can raise human rights issues. So they can say, well, it's all jolly well you're saying it's conducive to the public good to deport me, but look, I've got this, that, and the other Article 8 reason for wanting to stay. And the FTC would have to resolve that dispute.
Absolutely, but that, in my submission, does not undermine the submission that I'm seeking to put forward.
And also, if the FTT on appeal had said he had to be allowed in, as this FTT had done,
Yes.
they would have decided that issue on Article 8 grounds because of their view of conducive, and therefore the next tribunal would also be bound and would have to allow the appeal, wouldn't it, under Tomlinson?
Yes. Okay. So that, in my submission, reinforces the submission that I'm seeking to put forward, that allowing a person to enter the UK who has received a sentence of 12 months or more, not because of a separate proportionality analysis, not because the welfare of the child outweigh the public interest and and requires that person to enter the UK, but simply on the basis that the requirements of the rules are met and it would not be conducive for him to come to the UK, would lead, in my submission, to an absurd, incoherent situation. That a person comes to the UK in the circumstances when the rules and the policy would require his deportation once he is in the country, subject, of course, to proportionality exercise, etc. So, what is relevant in considering the question of conducive to the public good? The authority that may assist on that is behind tab 11 of the bundle, the judgment of this court in Donsu. So Donsu is a case involving a sex offender, a deportation appeal on human rights grounds. Mr. Donsu had rehabilitated well and posed no significant risk of reoffending. And on appeal, he argued that his deportation would not be conducive to the public good in light of that rehabilitation. If you look at paragraph 20 of the judgment, my Lords, my Lady, which you have at page 195, the second half of that paragraph, most sex offenders who are sentenced to substantial terms of imprisonment are offered courses designed to help them to avoid reoffending. But protection of public from harm is only one of the factors which makes it conducive to the public good to deport the criminals. I respectfully submit that that applies also to exclude criminals who are not in the country. And other factors include the need to mark public revulsion at the offender's conduct and deterrence. So those two are obviously relevant matters when a tribunal, the court, is considering a deportation appeal and is deciding whether a person's deportation is conducive to the public good. In my submission, they are equally relevant in deciding whether the exclusion of a criminal who is not in the UK is conducive to the public good. May I then take you to the decision of the First-Tier Tribunal and make submissions on grounds 1 to 4. The First-Tier Tribunal's decision starts at page 58 of the bundle. Paragraph 1, Lords, my Lady, you'll see that this was this is a human rights appeal brought solely on the human rights ground, that refusal of entry clearance is contrary to the Human Rights Act 1998. That is the only available ground of appeal. Now, if you then look at the heading, the hearing, just above paragraph 5, you'll see paragraphs 5 to 8. Now, these paragraphs will, in my submission, assist you in deciding the procedural objection that Miller and friends have raised. So, my lords will see that the appellant joined the hearing by a video link from Jamaica. Paragraph 6, at the beginning of the hearing, the appellant adduced a number of documents. Now, those documents included his witness statements and witness statement of his spouse and spouse's mother. Now, one authority that Miller and friends cite against me is the judgment of this court on procedural points, is the judgment of this court in AL. And a case called Lata. There is now a practice direction in place from the senior president as to how the appeals ought to be conducted. That wasn't followed in this case. So under the new regime, as the court would know, by a specific deadline, the appellant provides a skeleton argument and evidence. The Secretary of State conducts a review of that skeleton and evidence and provides a written document identifying the relevant issues, and there is then a hearing before a judge. Now, in this case, the Secretary of State had not reviewed the evidence that Mr. Spence had provided, because that evidence was provided at the beginning of the hearing.
Can I just double check the facts? In the supplementary bundle, tab 5, page 33, we have a skeleton argument which is undated and
Yes.
Appears to enter page 6, internal numbers. So that was the skeleton argument. And that was before the Secretary of State when she did her review.
Absolutely.
Right.
And that...
So it's just the evidence, which is the witness statements of the husband, the wife, and I think it's the in-laws.
Yes. So that skeleton, my lord, is frankly a hopeless skeleton argument.
Oh.
And it wasn't drafted, of course, by my learned friends. In fact, my learned friend, Mr. Brochwala, decided not to rely on that skeleton. So if you look at paragraph 7 of the judge's decision, you'll see that Mr. Brochwala said that he was instructed late and sought to argue the case on an entirely new basis.
So new or different should go in there, yes.
Yes, new is missing. So that's set out in the skeleton argument. Now, would not, of course, waste your time by asking you to look at the skeleton, but even a cursory reading would show that simply a sort of copy and paste exercise. It was a hopeless skeleton. But the point is that new evidence was provided at the beginning of the hearing to the presenting officer, together with a case that was entirely new from the case that was set out in the skeleton. Now, the presenting officer bravely decided not to seek the adjournment, but decided to proceed and said that she wouldn't take the issue. So this, in my submission, is the context in which you will decide whether or not there are new points that should be allowed. Paragraph 8. In my submission, this is remarkable. The judge heard evidence from the appellant's spouse and her mother. The appellant decided not to give evidence, despite the fact that he was present by video link, despite the fact that he had made a witness statement. It was his decision not to face cross-examination. So he was seeking to submit that he's now a reformed person. He has now changed, but decided not to give oral evidence. You'll see that the parties agreed the issues are set out at paragraph 9.
They're the issues to be determined, but they're not the issues to be determined. They're issues that may help determine on any analysis, isn't it?
Yes, I mean, unless you read issue 2 as a sort of proportionality issue, but yes, indeed.
The following issues 4 to be determined in this appeal. Is the appellant's exclusion from the United Kingdom conducive to the public good?
Yeah.
That would need to be expanded, because if so, the argument is the rules didn't apply and therefore he couldn't be refused. But that's nothing to do with any Article 8 balancing other than that the rules were met.
Yes. It may be that when the judge referred to exceptional circumstances, what the judge meant essentially is proportionality assessment.
Yeah. As I understand it, but I don't want to put words in anyone's mouth, because I want to test what's going on here. I think what's happened over the decades since the Human Rights Act was first enacted is that initially tribunals just did the exercise, pure and simple, under Article 8. And the government, and it's not a party point, because whoever's been in office, changes have been made. The government then decided that they weren't very happy about that approach, and so they were going to give as much guidance as possible. So what's happened is that first through the immigration rules, then in primary legislation, the Article 8 exercise has become structured.
Yes.
So that government and parliament has given a very clear indication to the tribunals of where it takes the view the public interest lies.
Yes.
But nevertheless, I think it's continued to be recognised that you couldn't completely exhaust the potential scope of Article 8. If you did that, you'd effectively be bypassing independent courts and tribunals.
Yes.
And so there's still some residual role, potentially, to be played by Article 8. But essentially what's happened, at least at the government's view, is that what is set out in the rules almost completely overlaps with what Article 8 would require.
Yes.
And so you end up applying the rules.
Yes.
Is that accurate?
Absolutely. I mean, subject only, Lord, with respect to the exceptional circumstances proviso, which there could be a case where the requirements of the rules are not met.
Precisely.
But there is something so exceptional that it makes the refusal disproportionate.
Yeah. But this may help to explain why
Indeed.
the tribunals, as you told us, in practice, don't ask the Article 8 questions. They used to. I can remember when I was in practice.
Yes.
I did cases like Huang.
Yes.
They went through, Lord Bigham set out what the questions are that the tribunal had to address. They don't do that as such anymore.
No.
They ask themselves the questions about whether the rules are satisfied in their judgment. But the reason why they're doing that is because everyone, in effect, agrees that that is the Article 8 exercise, subject to it not being absolute.
Yes.
And that's where the exceptional circumstances come in, I think.
Yes.
All right.
Absolutely. So this is how the tribunals, my lord, you're absolutely right, have been deciding cases for years now.
Right.
You'll then see a heading, findings and reasons.
Yes.
Is the appellant's exclusion from the UK conducive to the public good? And under that heading, the judge is making his own assessment as to whether the appellant's exclusion from the UK is or is not conducive to the public good.
Is the last sentence of that paragraph a correct approach?
The last sentence of
Paragraph 10, a correct approach?
well, no, with respect, because it is for the appellant to demonstrate that there is a breach of Article 8, and that
This isn't the starting point. The rules provide for exclusion on conducive good. The Secretary of State responsible for immigration policy has decided that it is conducive to the public good.
yes,
And the question then is whether there's some basis for departing from that, which leads to a conclusion that it would be disproportionate in this case. not to grant entry clearance. So how is it, and you haven't appealed it,
No.
that it's for the entry clearance to prove an abundance of probabilities? But you say that sentence is wrong.
Yes, but it's not, of course, a ground of appeal.
No.
Lord, I accept that. It wasn't a ground below.
Right.
And it's not, I mean, it is ultimately a matter of assessment. So the reason the reason why I have not taken the point, of course, I've taken other points, is essentially that if you look at the judge's analysis, it's not that he has allowed the appeal on a point about who bears the burden of
No,
proof.
but the point is, his starting point is, we've got a clean sheet. She's got to prove now
Yeah.
that it's conducive to the public good. And I thought we'd agreed some time ago that the starting point is the rules, then the decision. But if there was some reason to think that that wasn't a proper basis of proceeding, it may be that you can take that into account in the proportionality assessment. But this looks like a straightforward, it's for me to decide, no reference to Article 8 at all, whether it's...
But I think that is, sorry to interrupt, my lord, I think that's because of the discussion we were just having 5 minutes ago, because everyone agrees, and indeed it's the Secretary of State's position, that the rules encapsulate Article 8.
Yes,
And so that's why you end up applying the rule,
yes,
one way or the other.
yes. And the judge makes that decision.
But the question is the starting point. Is the starting point the Secretary of State is entitled to make the decision,
Yes,
and there has to be some basis for departing from it?
yes.
Or is it A, a clean slate, or B, not a clean slate, because the Secretary of State has to prove it in some way all over again? That's my concern.
Yeah. So the proper analysis in my submission is that the Secretary of State has made a decision, has made findings of fact. There is an appeal by the appellant. The appellant has to prove that the decision is unlawful under Section 6 of the 1998 Act.
Yes.
And it is for the appellant to persuade the tribunal that the rules are satisfied in the sense that he should be granted entry clearance, and that his refusal of entry clearance would be disproportionate.
Okay, well, anyway, you accept that this isn't one of your grounds of appeal, so you have got 5 grounds of appeal, which
Yes.
I'm anxious to get on to.
Great. So ground one is
Sorry, you were taking us through the text of the judgment. Do you want to finish that?
yes, but what I propose to do now, as I take you through
Yes.
the text of the judgment, is to also make submissions on my grounds.
All right.
So ground one, my lord, is primarily directed at paragraph 12 of the judge's decision. So this is where the judge says that I'm entitled to consider for myself whether the appellant's exclusion is conducive to the public good. In doing so, I need to pay particular regard to the entry clearance officer and the Secretary of State's views.
Yeah, that seems to me to be classically what the Human Rights Act exercise requires. And if you need authority for it, see Schwidler.
Yes. So no issue with that. But of course, the submission is that although the judge said that the judge was paying particular regard to the Secretary of State's views,
Yes.
the judge has failed to do so. Now, the Secretary of State's views, in my submission, are set out in the immigration rules and in her policy. The judge takes the view that a conviction in 2009 for which Mr. Spence received a sentence of 3 years was not enough to exclude him from the UK. That, in my submission, is a conclusion that is wrong in law. In arriving at that conclusion, the judge has failed to consider the immigration rules as a whole, the function they serve in the administration of immigration policy, and the Secretary of State's conducive policy.
Well, you may be right in that submission. I'm not saying you are, but you may be right. but I find it perfectly understandable what the tribunal's reasoning here is in paragraph 12. What the tribunal is saying is that they can see a contrast between the terms of SC 1.5 and SCC 1.4a to c over the page, and that the fact of the appellant's conviction is not by itself sufficient to exclude him under SCC 1.5. That seems to be accurate so far as it goes, because otherwise it would be an SEC 1.4 case.
Yes, but the submission that I make is that in arriving at that conclusion, what the judge has not taken into account is are the views of the Secretary of State set out in the deportation provisions and in the deportation policy.
Right.
And that, in my submission, is an error of law. The judge was obliged to read this particular rule against the relevant background. And the relevant background, as the judgment in Mahad tells us, are the immigration rules as a whole and function that they serve in the Secretary of State's policy. Now, that is not to say that if the conviction is sufficient to exclude Mr. Spence under the rules, that is the end of the Article 8 appeal, as my Lord Singh observed. Even if a person is excluded under the rule, that is not the end of the Article 8 appeal as such. There is still ultimately a proportionality assessment that had to be carried out. It would be open, for example, to Mr. Spence to say that, yes, I'm excluded under the rules, but the welfare of my child, for instance, justifies grant of entry clearance. But the judge's conclusion here is that he is not excluded under the rule, and that conclusion is wrong.
Yeah.
So that is ground one.
Yes.
Ground two arises from paragraphs 13 and 14. My Lords, if you look at the findings in that paragraph, you will see that the judge considered the likelihood of Mr. Spence committing further offences in the UK, and the judge was initially concerned with his sexual attraction to children and the risk that this might pose to children in the UK. The judge then refers to the fact that there are two instances and then a finding at the end that the appellant has been sexually attracted to children and has pursued relationships with children in the past. So this is an unchallenged finding of fact. But paragraph 14 in my submission is quite remarkable. These are unchallenged findings of fact. You will see that the appellant sought to downplay the significance of his offending against children. He provided false information to the Secretary of State. At one stage, he said that no sex was involved in his offending. And in the interview, he stated that his conviction arose from attending a party with a child. But the evidence before the judge, my lords and my lady, was that his offending included sexual intercourse with the victim. This is the evidence that his wife gave at the hearing. And you'll see that my learned friend, Mr. Broshwala, made an ingenious, with respect, an ingenious submission. He said that, well, the wife misunderstood. It wasn't sexual intercourse, but it was oral sex with a child.
His submission isn't evidence. The only evidence was what the mother said.
Yes.
Because Mr. Spence didn't give evidence.
Yeah. Yes. So, but you'll see that the judge quite properly said that whether it is sexual intercourse or oral sex with a child, it is far more serious than what was portrayed to the Secretary of State. There is a lack of candor about the nature of his offending, real doubts over whether he has truly addressed his sexual attraction to the children. So if I may just pause here and address you on the second ground. So when I addressed you on law, I showed you the judgment in Dansu. The relevant considerations are the need to mark public revulsion, deterrence, and the judge has not considered those matters at all in making his decision. The conduct is appalling. This is an extraordinary case in my submission where there would be genuine public revulsion. To know that a person who has been sexually attracted to children, who gave false information to the Secretary of State, who had, on the evidence, sexual intercourse with a child, and on submissions, oral sex with a child, is not being excluded. It's not simply about the risk of reoffending or risk posed to children. It is also about public revulsion and deterrence. It is absolutely essential in my submission for a message to go out, and that was the message that the Secretary of State was seeking to send when she refused the application, that no matter where you are, if you commit sexual offences against children, then one consequence of that is that you would not be allowed to come to the UK. And the judge has, in my submission, excluded from his consideration two relevant matters, and that is an error of law.
Sorry, what are the two relevant matters?
Public revulsion, the need to mark public revulsion.
It's that point again, yeah. Yeah, you may be right about that. I'm not saying you're wrong, but it just seems to me that even if one just takes the language of paragraphs 13 and 14 on its face, are you also making a narrower submission that this is incoherent on its own face? Because I'm looking at the last sentence of paragraph 14. The appellant's attempts to downplay his sexual involvement with children and his lack of candour about the nature of his offending, in my view, raised doubts over whether he has truly addressed his sexual attraction to children. If I read that, if I were a Crown Court sentencing judge and read a sentence like that in a pre-sentence report, I would think that's telling me this man remains a risk to children.
Yes. So that, my lord, is grounds 3 and 4.
Oh, I see. Sorry.
A challenge that reasoning is inadequate and the conclusion is perverse.
Yes, I see.
And the submission that I will make is that, well, on these findings, no reasonable decision maker could have come to the conclusion that this person is not a risk to children. But those are separate grounds. Ground 2 essentially is that, well, even assume that there is no risk to children, even assume that he is now a reformed character, that's not enough because the judge hasn't really looked at two relevant matters. Ground 3, my lord, and that concerns the first half of paragraph 15. The judge says that there are other matters to be taken into account. There is no evidential basis to conclude that the appellant continues to pursue sexual relationship with children. And the fact that there is a single offence and no subsequent convictions for similar offences leads the judge to conclude that the risk of the appellant reoffending in a similar manner is negligible. So, my lord, when you earlier asked a question about paragraph 10, said there is no ground of appeal that challenges the final sentence in paragraph 10. Of course, ground 3 challenges paragraph 15, and I do so on two bases. The first is that the judge effectively placed the burden on the entry clearance officer to show that Mr. Spence no longer pursues sexual relationship with children. there is no evidential basis, the judge says, to conclude that he continues to pursue sexual relationship with children.
There's no evidence either way.
Precisely.
It just isn't. All we have is his mother-in-law saying, I think he's a changed character, and Mrs. Ward Spence saying, I miss him very much.
Precisely. So the proper approach for the judge, in my submission, would have been to approach it on the basis, to ask himself, well, is there evidential basis to depart from the Secretary of State's assessment? Is there evidential basis to conclude that the appellant no longer pursues sexual relationship with children? So that
He's
is
sexually attracted to them, and you don't know where that's going to lead, yes.
yes. So that is the first point.
And the burden was on the respondent to show that, not on the Secretary of State.
Yes. So that is one point that I made under ground 3.
Yeah.
The second point concerns what the judge said about the risk of reoffending in a similar manner. In a similar manner. It's not, with respect, entirely clear what the judge meant. Now, the previous offending included on the evidence sexual intercourse with a child or oral sex on the submission. So even if, and I'll come to the fourth ground that this conclusion is perverse, but even if there is no risk of reoffending in that manner, namely sexual intercourse with a child, there's plainly a risk that he may commit other types of offences against children in the UK. So if, for example, someone has raped a child overseas, it is wrong approach for a judge to say that, well, there is no risk that he would rape a child in the UK. The judge has not excluded the possibility that he may commit different kind of sexual offences against children. And these two errors make his decision wrong in law, and that essentially is the third ground. Right. The fourth ground is that this conclusion is perverse and inadequately reasoned. No reasonable judge could have come to the conclusion that the judge arrives at in this case. That the findings made by the judge at paragraphs 13 and 14 are not challenged. And on those findings, the only conclusion available to the judge, in absence of any evidence from Mr. Spence, was that he poses a risk to children in the UK. But what this judge has said, second half of paragraph 15, is truly remarkable. The judge says, the fifth last line of that paragraph, the appellant is now 41 years old. He is now in a relationship with a 34-year-old person who was Mr. Spence's first victim.
At 15, we don't know whether or not they had sex. We actually only know that a 23-year-old man started a relationship with romantic overtones, to put it neutrally, when she was 8 years younger and underage. Do we know they had sex at 15?
My understanding is that they had.
How do we actually know that, though? Because it doesn't say it in paragraph 13. Was it in the witness statements?
No, I will check.
Was this the American offence?
No,
this is
the
offence in Jamaica.
This is
The encounter
yeah.
with the EWIs.
You might say it doesn't matter. 23-year-old man showing interest in a child whom he then goes on to marry.
Yes,
You might think, well, that's a very strange state of affairs. But in fairness, if it's not a sexual offence that he committed against his wife when she was underage, we ought to be sure about that.
Yes.
And I looked through the witness statements and it's unclear.
No. I think that there was something in the interview, but I will check that. And
But in the middle of paragraph 13, just before that passage, we do find this sentence. The appellant was convicted of sexual offence against a child under the age of 16
yes, so this
in
is
2008 when he was 25 years of age.
Mm-hmm.
this is
Is that the American one?
that
That's
is
the American one.
That's what I thought.
Yeah.
But
But it doesn't matter in my submission. But may I ask you respectfully to look at the second last sentence at paragraph 15.
Yes.
The appellant is in a genuine and subsistent relationship with an adult.
Yes.
And that suggests that he is now primarily sexually attracted to adults.
Yes. I don't mean any disrespect to this tribunal judge whatsoever. But this is a context in which those of us who have sat in the criminal courts might have the advantage that we have, I'm afraid, seen many cases
Yes.
where people are in subsisting relationships, and in fact, very often, the offence is committed against a child who is either a biological child or a stepchild.
Absolutely. So the fact that someone is in a relationship, in my submission, it is perverse to say that, well, that alone means that a person is not attracted to children. But there is a lot of further point, which concerns the use of word primarily by the judge.
I've highlighted that.
So that, in my submission, means that, well, if this finding was open to the judge, that it may be that he is now not primarily sexually attracted to children. Well, children are his secondary sexual interest.
Yes. Seems to me, but I don't want to put words in your mouth. It seems to me this is really a perversity challenge. It doesn't. I know you've pleaded inadequate reasoning. It seems to me you understand reasonably well why you've lost.
Yes.
But you say this is just not a conclusion reasonably open to the tribunal on what itself has just said.
Yes. I mean, of course, I have made both points in my skeleton grounds. It's either perverse, or I do say with respect, my lord, that the reader is unable to understand why this judge has decided, in light of his findings at paragraphs 13 and 14, that this person is no longer sexually attracted to children. So it's either inadequately reasoned or, in my submission, perverse.
I've just checked Mrs. Spence's statement and the witness and the interview record, and they met when she was 16, when she was on a family holiday with others, according to Mr. Spence, and they were just friends at the time she was 16, so he says, or in 2006 when she was 16, and the relation started when she came back on a second holiday when she was 17 or 18. So that's all we know, I think, from the evidence.
Yes, I said I do not seek to depart from paragraphs 13 and 14.
No, it's enough for your purposes, you say, yes.
So paragraph 13, there's a finding that there's a conviction, a child under 16 in 2008, and then his wife was 15 years old on a family holiday with the parents when he commenced relationship with the child. Now, whether or not it was sexual, in my submission, is beyond the point.
But he says he's working at the resort and the family were there, so I'm not sure, I mean, if it's true, how much we can put on that. He says that the relationship started when she was 70. You could read quite a lot into all of that,
of course.
And we haven't got the evidence.
No. And it was, hence I made the point that he decided not to face cross-examination, not to give oral evidence.
When these ambiguities could have been explored.
Yes, to challenge.
They first met when she was underage.
Yes.
When the relationship started and when it developed into a sexual relationship is unclear.
Yes. I mean, as I'm making a point about him giving evidence, that the court, of course, knows about a restriction on people giving evidence from abroad to courts in the UK. But Jamaica is on the list of the countries that allows its nationals to give evidence in immigration proceedings. So there was no bar on Mr. Spence in giving evidence. He was present. He joined the hearing, decided not to give evidence. So this conclusion, in my submission, is perverse. It's inadequately reasoned. If you then look at paragraph 16, you'll see that there is a further point. Now, if Mr. Spence had been convicted in the UK, he would have been subjected to a notification requirement for an indefinite period, essentially to protect children. The fact that his conviction is abroad means that there is no safeguard of that sort present. And the judge decided not to weigh that against the appellant. So you have a person who has been sexually attracted to children. The judge essentially is sanctioning his arrival in this country, knowing despite the fact that he would not be subject to requirements for the notification requirement, and that surely, in my submission, is a matter of law that weighs against Mr. Spence. It is all more desirable to keep a person out of the UK with that sort of conduct. The judge's ultimate conclusion is at paragraph 17, and that conclusion is that it would not be conducive to the public good to exclude him from the UK. His conduct does not make it undesirable for him to be given entry clearance, and for the reasons I have given, the ultimate conclusion is wrong in law. And you will see from paragraph 19 that the judge allowed...
At 17, I know he said once in the judgment, I have to bear in mind the views of the Secretary of State, but I still get the sense that he decided for himself, if I was the Secretary of State, would I let them in? He doesn't say, apart from once, that the Secretary of State's view under the rules is not to let him in, and they give weight to that, and there's nothing to depart from it. It does appear to be an exercise of discretion afresh on his part, but...
That is essentially...
Well, that's because that's the Article 8 exercise that they're performing. And they do say earlier that there has to be considerable weight given.
He says once, yes.
Yeah. That isn't really how you're putting the appeal.
No, it's not.
That they've performed the wrong exercise. You accept that they've performed the right exercise in principle under the Human Rights Act.
Yes.
But what you do submit is that putting it at its highest, and this may be all that you need, I don't know.
That's it.
But putting it at its highest.
The reason for that, my lord, is that...
Sorry, can I just finish? You say the conclusion reached by the tribunal in paragraph 17 is one that was not reasonably open to it, on its own earlier findings.
Yes. It is either perverse or I do say it's inadequately reasoned. The reason I'm making that point essentially is just to protect my position against the procedural objection that Miller and friends raised. They say that perversity point was not taken on appeal to the Upper Tribunal. And the point that was taken by the presenting officers on appeal from the Upper Tribunal was inadequate reasons.
Well, that may be right, and I'll listen to what Mr. Jafferty has to say about it, but it might be said by a reasonable member of the public that if a case comes before the Court of Appeal, which is truly perverse, that it would be surprising if this court can do nothing about it.
Yes, indeed.
But he may be right, but there's nothing we can do about it.
Yes. So, and then just finally, if you look at the final sentence of paragraph 19, why the judge allowed the Article 8 appeal, the judge said that all the requirements of the immigration rules are met.
Yes.
And Mr. Spence does not fall for refusal on suitability grounds. And that essentially strikes the balance, the judge says, in Mr. Spence's favor, essentially applying the TZ approach, that if you meet the requirements of the rules, then that is essentially the end of the proportionality balance.
He's finding, just to make clear that I've understood it, because he takes a different view about conducive to the public good, therefore he should have met the rules, and not to allow him in would be a breach of Article 8. In fact, that's what he's saying, isn't it? There's nothing else.
Nothing else. Of course, apart from the fact that the judge is saying that all other requirements are met, eligibility, relationship.
They are.
They are met, yes. Yes.
That was the Secretary of State's decision that they were met.
Yes, indeed. And this conclusion, therefore, is one that is wrong in law. Now, may I then just show you the Upper Tribunal's decision that starts at page 36.
Sorry, just going back to paragraph 17, I'm just on rereading the first sentence. The FTT judge appears to have accepted that the relationship with the respondent's now wife was a sexual relationship, because the FTT judge refers to his history of pursuing sexual relationships with children.
Children.
So that does seem to show
That relationship with both was
both,
sexual.
yes, and they were both children at the time.
Or at least that he's pursuing it,
Yes.
whether it came to pass or not. The
Yes.
thing is, he's looking for young girls.
Yes.
Right. You're going to show us the Upper
The
Tribunal.
Upper Tribunal's decision, page 36. And may I take you to page 43, where the discussion starts.
Yes.
Of course, I will address very briefly the reasons given by the Upper Tribunal. The focus ought to be, in my submission, the First-Tier Tribunal's decision. The question as to whether the first-tier erred or not is a question for this court on the second appeal. So ground one was that the findings were at odds with the conviction. It wasn't sort of expressly said that this is a perversity challenge, but in my submission, this is what the presenting officer was trying to say. That look at the judge's conclusion at paragraphs 13 and 14, the paragraphs that I've taken you to, and then the conclusion doesn't add up.
I mean, you could say that the way that the Upper Tribunal summarises ground one is a very succinct way of putting the perversity test.
Yes.
Findings that were at odds
odds.
with.
Yes, yes.
Do we actually have the grounds of, we have the grounds of appeal. It might be helpful to have them open. I couldn't, are they in the core bundle? I read them this morning again.
They are, but my lord, with respect, I'm not sure if the grounds would assist. Page 68 of the bundle. Page 68 of the bundle, you'll see two broad headings: making a material misdirection in law.
That's where the paragraph 2 is where the Upper Tribunal got the phrase at odds with.
At odds, yeah.
That's in the third line.
Yeah. Yes.
And again at. So the implication is, again, that's also what's complained about in paragraph 3 is also at odds with.
Yes.
I mean, that's what you were saying this morning, effectively.
Yes, and of course you'll read that with paragraph 5 that despite the fact that it was over 10 years ago, he hasn't reoffended. The fact is that he has maintained relationship with his partner and child from overseas.
And then paragraph 6, Judge Greer's failed to provide any reasoning on that point.
Yeah.
I wanted the word.
So there's no dispute that there was a reasons finding, but may I ask you to see how that paragraph ends? The author says that the judge's assessment that there is no risk is essentially subjective, and that, in my submission, is a perversity challenge.
Yeah, trying to get to it, yeah.
So the author is saying that, well, this isn't an objective decision.
So it isn't put in sort of lawyer's technical language, but those are the essential points that the author is getting at.
Yes. So the submission that I make is that it's absolutely clear that there was a reasons challenge. It's absolutely clear that there was a perversity challenge. there is, of course, no reference to the deportation provision and conducive policy, or the public revulsion point that I made. But one gets that in my submission from paragraph 15, where the author essentially says that despite the fact that it's quite old, despite the fact that there is no reoffending, those are sort of neutral matters, not matters that weigh in favor of Mr. Spence. And then ground 2 concerns material misdirection in law of Article 8, and I'll address that shortly. So just taking you back to page 43 of the bundle, the judge concludes that in the Upper Tribunal, paragraph 25, the submission is rejected when the decision is considered holistically, including the findings. You'll see that the judge concluded that the finding that there was risk of reoffending in a similar manner was negligible. That was a finding open to the judge. There is misdirection in law, but that ground is rejected. And that, in my submission, does not answer up any of the points that I've made. Paragraph 31 is where the Upper Tribunal says that the fact that he hasn't reoffended, etc., are not sort of neutral matters, and they could probably be taken into account in the exercise of discretion by the judge. Well, that, in my submission, is wrong. Everyone is expected to comply with law, and everyone is expected not to have sexual relationship with children. So the fact that Mr. Spence has not reoffended, there isn't any conviction, it's not a matter that goes in his favor in the balancing exercise. At best, it's merely an entirely neutral factor. Paragraph 32, in my opinion, is indefensible. The judge in the Upper Tribunal says that the assessment of risk is likely to be subjective, and there's nothing wrong with that. That is plainly wrong. I mean, the assessment of risk is objective. The task of the judge was to decide whether objectively this person presents a risk to children. Paragraph 33, with respect, is impossible to follow. It's not clear at all as to what, say, this with respect, that the Upper Tribunal was trying to say. There are repeated references to discretion, but this isn't a discretionary exercise.
I mean, I still find parts of this very odd. The ECO was in the middle, was entitled to exercise his discretion in the way he did when refusing OS's application for entry clearance. FTT, quite correctly, not required to assess the lawfulness, but he was entitled to exercise his own discretion. It's not as if it's a discretion in the light of what has already been decided, to see if what's been decided is disproportionate. It does appear, I'm afraid, to be saying this is a fresh, new exercise. And that I don't think is right, is it?
Yes. Yes. So, I mean, of course, this takes us back to the discussion that we had at the outset.
It seems to me, speaking of myself, the language of discretion is wholly inapt.
Yeah.
But they are getting at sort of the right point, which is this is not a judicial review exercise.
Yes.
So the tribunal, there's only one ground of appeal, breach of Section 6 of the Human Rights Act. That's a question the tribunal has to answer for itself.
Yeah.
So it's not engaged in reviewing. So it's perfectly possible, perfectly coherent to say the ECO was entitled to exercise its discretion in the way it did when refusing OS's application for entry clearance. But that doesn't answer the Human Rights Act question.
Yes.
So where this gets anyone, I'm not sure.
What I think is missing here, just that Mr. Jafferji knows as well, is that it's almost as if it's a clean slate. Well, he decided that, and that's fine, he can do what he likes. But I'm going to decide it now. But that isn't the exercise. The question is, having regard to what's been decided, can I legitimately take the view that it's disproportionate to exclude him? And there doesn't seem to be any connection between those two things.
My Lord, if you put it in that way, then I expect to not see a difference between that and the observation that my Lord Justice Singh.
Yeah.
No,
I don't think we disagree.
No, we're not in disagreement.
Yeah.
Speaking for myself, and this is not a comment on this case,
Yes.
something that has bedeviled the entirety of our legal system
Yes.
for the last 26 years is that people seem to think that Section 6 of the Human Rights Act is something difficult.
Yes.
But it's done day in, day out, all the time, in lots of different contexts.
Yes.
In the extradition, well, we have the advantage that we see appeals from right across the legal system.
Yes.
This is what courts and tribunals do, and they're expected to do it.
Yes.
In extradition, it's done on a fairly routine basis. It's actually quite short judgments. Lord Thomas recommended a balance sheet approach, that you put on one side of the balance what are the factors conducive to extradition, and on the other side, the factors weighing against extradition. And then you form a judgment. That's what courts and tribunals have to do, form a judgment.
Yes.
And of course you take into account and you give weight to the fact that the Secretary of State has taken the view that she has. But that's not the end of the inquiry either.
No.
You can't shirk your duty. You've got to do your duty. But I don't find it myself actually very difficult. I've done proportionality exercises and still do them. It's not actually very difficult. We did it recently in the VAT. It's very high-profile primary legislation, VAT on school fees.
Yes.
We did the exercise. So it's not enough the government and Parliament take the view they do,
Yes.
and end of, or that we somehow have to have a hands-off approach to it. We looked at it. We gave it a very hard look, and we said, this is all right.
I wonder if you would agree with this formulation, Mr. Malik. This is not a clear slate. It's not a fresh exercise of discretion. The question is whether, given what has been decided by the Secretary of State, there is some reason for saying that is wrong, or something to show that the result is disproportionate, such that giving effect to that decision would be a breach of Article 8.
Yes. 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 Yes, and that, I exactly agree. I mean, that of course would not cut across the tribunal's jurisdiction. The judge will still make their own decision. But of course, if there is evidence,
well, the decision they make is slightly different. I mean, if it's wrong, I mean, it could be he wasn't convicted, they've got the wrong person, and so on. But simply to say, I don't agree, wouldn't be enough.
Yeah. So, absolutely. So no difficulty, my lord, with that. So this decision that holds that there is no error of law in the First-Tier Tribunal's decision, in my submission, is wrong.
Yep. Well, you haven't dealt with ground 2. They deal with it at paragraphs 35 and following.
Yeah.
Do you want to say anything about that?
Yes. Now that really is my final fifth ground.
Oh, I see. Right.
Yeah, ground 5, which concerns Article 8.
I see.
And that, of course, is a distinct ground in the sense that grounds 1 to 4 are directed essentially to the rules, and ground 5 is a distinct ground on Article 8. But before I address you on 35 to 36, may I just show you very quickly what the First-Tier Tribunal judge said on Article 8 as to why that article was engaged. If you go to page 62 of the bundle, So what, structurally, what this judge should have done is that this judge should have started with the point that he made at paragraph 18 at the outset. So the first question for the judge was whether Article 8 is engaged. And you then look at the relevant rules, etc. So the judge found that the requirements of the rules are met and then turn to Article 8. And then, my Lord, will see that the judge says that Article 8 is engaged because the ECO's decision causes an interference with the appellant's family life. This is the family life of Mr. Spence, and the opportunity for the appellant to undertake full marital relations with his wife. And the judge says that, well, that engages Article 8. That, in my submission, is wrong in law. Mr. Spence has no Article 8 right to come to the UK. He is not in the jurisdiction of the UK. And cannot rely, in my submission, on Article 8 to say that, well, there is a decision that interference with his ability to have relations with his wife. What is engaged, in my submission, is the Article 8 right of the wife.
And the child.
And the child.
And the child, which the judge hasn't really dealt with at all at paragraph
He doesn't
18.
consider it at all.
Yeah. So, I mean, if an authority is needed for this proposition, that it's not the appellant's Article 8 rights who is abroad is engaged, then it's the judgment of this court in a case called Abbas.
Yeah. Well, just tell me where you're going with this. I mean, I understand that he's outside the jurisdiction and he's actually seeking a positive obligation to be allowed to be admitted. But his wife and child are here, so Article 8 applies to this situation, and he can bring in an appeal and rely on Article 8, and you'd have to measure the impact on the wife and the child of them being excluded.
Yes.
But the appeal can still be brought by him in his own name.
Absolutely.
Yeah, so you're not saying that then. So
No,
it's
not.
just that we're not bearing in mind that he's never been here. And
No, absolutely not. The complaint simply is that the judge hasn't really focused on the rights of the wife and child. The judge isn't saying that, well, Article 8 is engaged because the wife's Article 8 rights are engaged, the child's Article 8 rights are engaged. The impact on them is not dealt with at all.
Well, he doesn't seem to think he's got to deal with any other aspect of Article 8 because he's taken the decision that it's within the rules, and therefore any failure to comply with the rules is a breach of Article 8.
Yeah.
But in fairness, that's exactly how the Home Office puts its case.
Yes.
They say the rules comply with Article 8, so what you do is not a freestanding Article 8 analysis. You have to do it through our rules, because we've told you what you have to weigh in the balance and so on and so forth.
Well, subject, of course, to this, my lord, that Article 8 must be engaged.
Oh yes, no, I understand that. But why would this be a material error of law if, in fact, there are Article 8 rights here, namely the wife's and the child's? Where does this get you? Why does it even matter?
Well, the judge hasn't really made any finding about the rights of the wife and child.
So he hasn't made any findings about the impact,
The impact
of
on
the
them
separation on the wife and the child. There's just a complete blank there.
at all, yes.
Yes. I mean, in many cases, albeit they tend to concern deportation
Yes.
rather than refusal of entry clearance, but in many cases there are detailed findings about whether, for example, family unity could be maintained in another country.
Yes, indeed.
What would be the impact? The age of the child. I mean, when I was still in practice, I remember dealing with cases in Strasbourg where it seemed to make a difference if somebody was in secondary education rather than an infant, for example. It was much harder to say it was a proportionate decision it's going to disrupt their GCSEs or something. Those are the kinds of detailed findings one would expect, and your submission basically is none of this has been gone into.
And this isn't, my lord, you're absolutely right to point to that example. This isn't a case where the Secretary of State is interfering with an existing state of affairs. The wife is in this country with a child.
Yes.
They have maintained their relationship over the last 15 years.
Can I just be absolutely that the husband has never been in the United Kingdom?
No.
And the implication of the witness statements, his and hers, which adopts his, is that the mother and child have always resided in the United Kingdom. They have had holidays together in Mexico and various other places. So that is the factual position, is they've never lived together as husband and wife, and they've never lived together as a family of three.
That is correct, yes. Yes.
It might be thought it's one thing to say, well, if you meet the requirements of the rules, then it would be disproportionate to refuse entry clearance. In circumstances where the rules you're talking about are the rules which are a proxy for the Strasbourg jurisprudence, so all the stuff about insurmountable objects, obstacles and unduly harsh and all the rest of it. The problem with this analysis, potentially, is that this particular rule only focuses on the conduct of the person who's applied for entry clearance. So this particular rule is not a proxy for the Article 8 exercise. Do you see the point I'm making?
Well, I thought you were saying it is.
Well,
now,
I mean,
yes.
Because I think we have to be very careful about this, because anything we say in this case, we might queer the pitch in many, many other cases. Just standing back from it for a moment. If somebody is married to somebody who lives in this country, that is, many ordinary people would say that is potentially an interference with family life, because you're by barring entry clearance, you are effectively disrupting family unity. And I know we have all the point about they can live overseas and so on, but actually, most people would take the view that it's a matter for families to choose where they live. Because it may depend on where they have work, for example, where a child is at school and so on and so on. So I think we need to be very careful. I had understood your submissions for the whole of this morning so far to be that, so far as the Home Office is concerned, the rules which it has promulgated are occupying the territory of Article 8.
Yes, absolutely. So when Milady asked the question that, well, this rule perhaps would not reflect the balance, that is, with respect, correct in the sense that, well, this rule alone is not the rule to be applied to decide whether the balance is correctly struck. But all the rules are relevant. So rules as a whole reflect the Secretary of State's policy and the balance that is to be struck. So if all the requirements of the rules are met, then of course the authority tells us that is determinative of the proportionality assessment. So it's not simply one rule, but the entire body of the rules.
But there is no other rule. The only rule that's relevant here is that one you've shown us about conducive to the public good. There is no other rule in issue, and I think the point that's being made really is this is not a removal or deportation decision where you are breaking something up and you have insurmountable obstacles and so on as a reflection of when it wouldn't be right to break somebody up.
No, I do not make
what's
that.
being said is that this is a situation where they want to join after 11 years or 15 in the case of the wife of never being together. And therefore, even if it wasn't conducive, that wouldn't give you the right to say, I want to come and live with my wife, she lives here, and I'm entitled to live wherever she lives, because that's not what the rules say.
No,
Although he would meet all the other rules in this case.
Yes, well, I think, speaking for myself, I think we need to be very careful about this, because if you didn't have a criminal, right, if you just had, say, a professor of law at Harvard, whose wife is a professor of law at Cambridge,
Let him in.
and they say that on grounds of marital unity, I think Article 8 might have a lot to say.
Yeah,
If you said to them, no, you can live in Cambridge, Massachusetts, rather than Cambridge, England, I'm not sure we can just say, well, that's not an interference with family life.
No, I do not make that point. So, for instance, if the spouse isn't working, they do not meet the income threshold.
Yeah, exactly.
Then there could be another public interest reason to
Precisely.
exclude.
Exactly.
But I do not say, my lords, that if the judge was entitled to conclude that that all the requirements of the rules are met, and if Article 8 is engaged,
Yeah.
there is some other discrete reason why the appeal should fail.
Yeah.
But ground 5 is a complaint that the judge was wrong in law to find that Article 8 is engaged because the focus of the judge's assessment was the right of the appellant in the circumstances when the appellant has no Article 8 right.
But what's the answer to my lord's point that doesn't matter?
It does matter, yeah.
But it doesn't matter at all because the only issue is the rules. And if he qualifies under the rules, he gets in. If he doesn't qualify, he doesn't get in. And Article 8 does apply, if we leave aside the word engaged, it does apply because at least 2 of the people in this triangle are British and are living here. So it doesn't make a difference, does it?
So the way I see the point, of course, that there's a potential point,
Yes.
a good point to argue that there is Article 8 is engaged.
Yeah. Well, we understand your ground 5.
Yeah,
It may not be your best ground.
No, but can I just say this, my lord, if, given the observation that you have made, why I made that point.
Yes.
Now, when I drafted the skeleton, there was a conflict of authority at the Upper Tribunal level.
Yes.
You may have seen a reference to a case called Al-Hassan,
Yes.
Oh, yes.
which was about engagement of Article 8,
Yeah.
which was directly inconsistent with another reported decision called KF.
Yes.
And the submission was that it's appropriate for the court to consider the conflict and resolve it. Well, that conflict has now been resolved by a case called IA and others.
Yes. By this court.
By this court, yes. It's tab 22. I will not take you to that.
So it wasn't the ground below and it's not material to this, so I wonder whether we need to worry too much about it.
So I'll leave that.
On your grounds 1 to 4, assuming you're correct on those, and that they were wrong to treat the compliance with the rules as dispositive because they're just wrong, do we have to remit rather than remake ourselves? Because there's still got to be evidence about other factors. What would be the effect on the child, particularly if he wasn't allowed to come in?
Yes.
Or can we decide it ourselves?
Lord, it really comes down to on what you accept and what you reject. If you accept my perversity challenge, and if you conclude that, well, the only conclusion available to a judge is that it is undesirable for this person to be given entry clearance, it is conducive to public good to exclude him. And if that is the only conclusion that is available, then in my submission, this court can properly substitute a decision dismissing the underlying appeal.
How? Because there would still be the possibility that notwithstanding
Yes.
he doesn't meet the rules, there could be exceptional circumstances.
But there are none on the evidence. You'll hear from 11 friends.
But this is where Mr. Jaffergy's complaint that this is not how it's been pleaded in the grounds below may be relevant, because I think I'm not saying I agree with him, but one of the points he makes is that if they had known how the Home Office were going to argue the case below, they might have adduced other evidence. So the way in which the proceedings have been conducted might have been different. And that's the approach which this court tends to take in the authority of Singh and Das, which is not an immigration case, but generally.
Yes.
When we ask ourselves whether we should allow a new point of law
Yes.
to be argued in this court,
Yes.
we usually take into account whether it's a pure point of law or whether it might have made a difference to the way in which the case was presented below, including possibly adducing evidence. Now, I think what will be said against you is that perversity was not argued below as such, and that you might have to have evidence, for example, about the impact on the child before you could reach a final view on these things. I'm not saying I agree with that, but I think I can see procedural difficulties.
Nice. So the way I'll seek to answer that question is this, that in the decision refusing the application for entry clearance, the Secretary of State said that your conduct is such that it would be undesirable for you to be given entry clearance. The decision maker said that there were no exceptional circumstances in the alternative. So that was the Secretary of State's position. The appellant had used his evidence, and that was the appellant's opportunity in my submission to seek to undermine the Secretary of State's conclusion. All the appellant had used, essentially on the day of the hearing, is the evidence that you have seen.
The only thing we're missing, because it's not recorded, is the cross-examination of the mother, and I don't know if the mother-in-law also gave evidence. But we have the witness statement of the mother and the father and the mother-in-law. We have all the witness statements that they gave, and there's some other letters that they sent in.
Yes.
And I can understand your submission that if you read that evidence, they're not putting forward any other facts. The only fact is the child gets upset when the video calls terminate or when the phone terminates, and they would like him to be there as part of a family and like him to be there for Christmas and celebrations. But what if the mother said something orally, or are we just too...
No, I mean, if the mother had said something orally that was relevant, then Miller and Friends would have adduced that before the court.
If the child was ill or something, then
Yes.
we'd have had it. So you say
So-
we've got all the evidence that they chose to put in.
Precisely. So the proper approach that of this court with respect is to look at this evidence and see if on this evidence there is a possibility, a real possibility of a different outcome. If Miller and Friends persuade you that there is a possibility that one judge on this evidence could find in favor of Mr. Spence, then the court will allow the appeal and remit the appeal for a fresh hearing to the Upper Tribunal or to the First-Tier Tribunal. But if the court concludes that there is no prospect of a different outcome, then the court will dismiss the appeal. And I
No, you don't want the appeal dismissed. I thought you wanted to allow it.
No, you will
Oh,
dismiss
dismiss that appeal.
The underlying appeal.
All right,
You
sorry, yeah.
will allow my appeal and you will dismiss.
Right.
You will substitute a decision dismissing the underlying
Yes.
appeal. So these are my submissions. May I just make one final point?
Can I just check? You're using the language of simplex and so on. We're not setting aside the Upper Tribunal decision and remaking the decision, are we? We're not doing in that territory.
No, my lord. But I mean, if you are persuaded, what you will do is that you will set aside the Upper Tribunal's decision.
And
You
set
will
aside the FTT.
set aside the First-Tier Tribunal's decision, and you will then say that the appeal against the entry clearance officer's decision is dismissed.
Yes.
And we can do that because we've got all the powers of the Upper Tribunal.
Yes, and the statute expressly says so.
Yeah.
And this court has done
Yeah.
many times in other cases.
Yeah.
Just one final point. The authority that is cited against me on procedural issues is the judgment in AL and
Yes.
Tata. In my submission, that is a remarkably different case from this case for all the reasons that I have given.
I'm being very slow, Mr. Malik. Could you just give me the section that says we can set aside the Upper Tribunal decision, set aside the FTT decision, and dismiss the appeal against the decision of the Secretary of State? Is that a section in the 2007 Act?
Yes, it's Section 14 of the Tribunals, Courts and Enforcement Act 2007.
Perfect. Thank you very much.
Thank you.
No, I hate to leave anything not checked. Yes, thank you.
Yes. Any other questions?
No.
Any other questions? No. Thank you
Very
very
good.
much.
Thank you.
Thank you. Yes, Mr. Jeffrey.
My lords, my lady, I'm grateful. If I could start by taking you to the authorities bundle and asking you to have page 8, which I think is tab 2.
Yes, thank you.
That is Appendix FM to the Immigration Rules, which is the section of the rules that was applicable to the respondent's application for entry clearance. And my lords and my lady will see that right at the outset of Appendix FM, under Gen 1.1, subheading Purpose, the rules in this section of the immigration rules expressly relate to family life.
Yes. With a person who is either a citizen or settled in the UK.
My lord, yes.
And is in the UK.
And my lord and my lady will see as you get about just over halfway through Gen 1.1, the rule itself states that Appendix FM sets out the requirements to be met, and in considering applications under this route, it reflects how, under Article 8 of the Human Rights Convention, the balance will be struck between the right to respect for private and family life and the legitimate aims of protecting national security, public safety, and the economic well-being of the UK, the prevention of disorder and crime, etc., etc. So the rule itself is designed to provide a complete assessment of Article 8, but of course, if you don't meet the requirements of the rules, the tribunal must, and the Secretary of State must, give consideration to an assessment of proportionality under Article 8 outside of the specific provisions of the rules.
Yes. As I understand it, the government's view has always been that this does the job.
My lord, yes.
This is how an Article 8 exercise should be performed.
And this
But they had to recognise that they might have got it slightly wrong, so they always have to allow for the safety valve.
My lord, yes.
That even if you don't comply with these rules, you may still argue Article 8.
Yes.
But certainly from their point of view, it's intended to cover the territory of Article 8. And that's why the authorities now hold that if you do comply with the terms of the rules, then a contrary decision would be disproportionate and therefore unlawful.
My lord, yes.
Right.
And that is the way in which the First-Tier Tribunal approached the appeal. Understandably, that is the way in which the respondent approached the appeal and approached the decision-making process. If I could then take you back right to the beginning and the decision of the entry clearance officer, which was the subject of the appeal before the First-Tier Tribunal. That is the last document in the core bundle. It's page 73. The decision dated the 1st of September 2023. And on the second page of the decision, you have the reasons for the refusal. It says in the first paragraph that your application has been considered by reference to Appendix FM on the basis of your family life, with your partner and child, considered with reference to Article 8, which is all consistent with what we've just seen in Appendix FM. And then the only ground for refusal under that framework that the appellant has set herself is suitability. You will see that all the other requirements under the rules are expressly stated to have been met. Exceptional circumstances is different because that comes after failure to meet the requirements of the rule. And it's suitability that contains the reasoning for the refusal. And if I could ask my lords and my ladies to just very quickly read the subsection on suitability. this is the reasoning of the primary decision maker.
But if you go down to the bottom of the page, Mr. Jappaji, you will see that having refused the application, because the Secretary of State considers giving entry clearance is not conducive to the public good, the decision maker goes on to consider, under paragraphs Gen 3.1 and 3.2, Appendix FM, whether there are exceptional circumstances which would render refusal a breach of Article 8, blah, 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 and decides that you have provided no information or evidence to establish that there are any exceptional circumstances in your case. So the decision maker hasn't simply said, I refuse because in the exercise of my judgment, your admission is not conducive to public good. The decision maker goes on to consider whether those exceptional circumstances relation to Article 8 apply, and says no.
My lady, yes, absolutely, and that is the structure, so that you have the primary provisions in the rules that give the framework for what is acceptable, or what is expected. If you meet those, you don't get into exceptional circumstances. There's no reason for it. And if you don't, then there is the exceptional circumstances assessment.
And speaking of myself, this may also help to explain the structure of the issues that were identified by the FTT.
My lord, yes, and agreed between the parties. So the parties presented these as the issues, and in my submission that was absolutely consistent with the decision and correct as a framework for the way in which tribunals day in, day out make these decisions, which is to first of all assess whether the Secretary of State's own assessment of proportionality in such circumstances is met. If it is, there is no need to go on and consider a full-blown proportionality assessment.
Well, hold on a moment. It's not the Secretary of State's assessment of proportionality at the first stage. At the first stage, what's at issue is whether that the Secretary of State has decided that it's not conducive to the public good, which is a focus on the character, conduct and associations of the applicant, and not a focus on anything else.
Well, I mean, the framework of the rules as a whole, so the primary framework under Appendix FM is the Secretary of State's assessment of what is proportionate. And within that, you have the suitability provision at 1.5, which says that if there is an assessment that it is not conducive to the public good and undesirable to allow somebody, then that leads to a refusal.
Yeah, as you pointed out, and we mustn't lose sight of this, the rules contain a number of other expressed requirements. Language, financial, all of those are met.
All of those are met.
But in other cases, they're not met.
My lord, yes.
And the Secretary of State stance, as I understand it, is because you can't speak English, for example, to a requisite level, because you don't meet the eligibility financial requirement, I'm refusing you. It is family unity, even though you're sitting in California and your spouse is sitting in London, and I am refusing you because you speak Spanish and you can't speak English, for example. And the Secretary of State's position, as I understand it, is that is proportionate under the Human Rights Act. So I think what you're saying is that they have designed this rule to cover the territory of Article 8. And as it happens, in this case, the only reason why there was a refusal under the rule was the suitability criteria. So
that is exactly what I'm saying. And therefore, the focus of the first-tier tribunal judge on the suitability requirement is understandable, and actually my submission correct in terms of the first line of inquiry that a tribunal judge must perform. That is consistent with the outcome and the dicta in TZ Pakistan, which my learned friend took you to earlier this morning from the Court of Appeal. And I'll take my laws and marry to that later, perhaps. But my point is that this is the framework for the appeal, and the reasons given under the suitability subheading of the refusal do not reflect the depth and eloquent submissions made by my learned friend today. It is a very straightforward refusal on suitability grounds. It simply says you have been convicted of a criminal offence, so it's identifying the single criminal offence, sentenced to 3 years imprisonment, you fail to declare it, and then I've considered the circumstances of the application, I'm not prepared to exercise discretion in your favour. There is no suggestion in the primary decision that was under appeal that there was a wider concern about his conduct, apart from the fact that he failed to disclose the previous conviction in his application and the fact of the previous conviction. And that is it. The nature of the conviction is not even referred to in the refusal. And in my submission, that is important to bear in mind, because the Secretary of State's position with respect to the respondent's application has evolved over time as this matter has progressed in the appeal system. And I'll take my lords to the...
Well, truly, the records, we haven't seen the records. They would have said what he was convicted of. They must have known it was a child offence, mustn't they?
My lord, I have no doubt that the entry clearance officer was aware of the nature of the offence. My point is that the nature of the offence was not the reason for finding that the suitability ground was not made out. It was simply on the basis of a previous conviction. You were sentenced to 3 years imprisonment, you have a previous conviction. That is the reason why I find that you're not suitable and that your admission is undesirable. That is this decision.
I understand all of that, but I'm not sure how far this is really taking your case, because, as everyone has agreed, the task of the tribunal is not a judicial review task. So we're not really, I'm afraid, I don't mean this with disrespect, we're not really interested in what the Secretary of State originally said. What we're interested in is whether the FTT made a material error of law.
My lord, yes.
The only ground of appeal was breach of the Human Rights Act.
Yes.
And that was a good ground or it was a bad ground, but that's the ground of appeal.
My lord, I accept that, but my point is that this must be the starting point for the FTT, and then one has to look at what was before the FTT and what the FTT did with it, both in terms of the case that was advanced on behalf of the Secretary of State before the First-Tier Tribunal, in terms of evidence and submissions, and the First-Tier Tribunal's assessment of all of that, which in my submission went beyond what the Secretary of State was asking the First-Tier Tribunal to take into account, properly took very serious account both of the historic offence, which is the only thing that is identified in the entry clearance officer's refusal, but also took into account of other conduct, which is not referenced in the refusal decision.
Does that matter? The question is, the Secretary of State has not allowed this man to come to England. She didn't allow it because he'd been convicted of a child sex offence. The question for the tribunal is, was that decision disproportionate? Answer, gosh, not only has he been convicted of a sexual offence against children, he's had other attractions to children. He's downplayed it, and he's primarily, but not solely, attracted to adults now. Why isn't that enough for the tribunal to say, well, we don't think the decision was disproportionate or a breach of Article 8? When you look at all of that, there's nothing disproportionate.
My lord, that is the perversity challenge, and that is the assessment that, well, in light of your findings, your assessment that the suitability requirement was satisfied by the respondent, or looking at the other way, that the appellant was wrong in her suitability assessment, was perverse. That is the perverse ground, and I'll take my lords and my lady through the determination, because my submission is that when one looks at the determination as a whole, and I will, my lords and lady, take you, of course, on behalf of the respondent, through the various cases from the Supreme Court and the Court of Appeal that tell us how one should examine the reasoning and the wording of determinations of the First-Tier Tribunal and the Upper Tribunal, which is a specialist tribunal dealing with these matters day in, day out, and whether one can focus on particular words and particular turns of phrases and assume that they have made the error, which a self-direction has told them not to, and which one would expect that they would not make. Clearly, this judge had in mind that the nature of the offending, the nature of the behaviour, was unacceptable. Clearly he had that in mind, because that is repeatedly asserted in the determination. The point is, did the judge eventually take account of all relevant matters and consider, well, actually now, I do not consider that there is any risk. and therefore I do not consider that there is a suitability issue? And was that a judgment that was outside of what is reasonable? Was it perverse, or did it leave out anything that should have been taken into account?
Can I suggest, Mr. Jafferty, a slightly different way of looking at it? We haven't got the appeal provisions, the statutory appeal provisions in front of us, but my recollection is that the premise of the right of appeal, the grant of the right of appeal, is that the Secretary of State has refused a human rights claim, and the issue on a human rights appeal is whether the refusal is a breach of convention rights. So the nuts and bolts of the reasons for the refusal are not an issue for the FTT. That's a given, and what the FTT has to consider on the appeal is whether that refusal, for the reasons it was given, breaches Article 8.
Yes, that must be right, my lady. That must be right. But in assessing that, the tribunal is focusing on the reasons given by the Secretary of State for finding that interference would be proportionate, and that was the suitability ground.
Well, but that's not how it's reasoned, is it? Because the way it's just leave aside the Secretary of State's reasons for making the decision. The making of the refusal decision is water under the bridge. You get to the FTT because you say your human rights claim has been refused, and then the FTT has to work out whether the refusal is proportionate or not. It doesn't matter that the Secretary of State says it's conducive to the public good to exclude this person. The straightforward issue for the FTT is, does this refusal breach Article 8?
Yes, my lady, I do not think that is controversial. That must be the FTT's task, but the FTT's task must be informed by the position of the parties before it. And if the position of the Secretary of State is the reason why interference is proportionate is because of the suitability requirement, then that surely must be the focus of the FTT's assessment of proportionality, the primary focus. If the FTT had found that suitability was a problem for the respondent, then the FTT would have had to go on to consider proportionality overall as a whole. But
is it competent for the FTT on a human rights appeal to assume the Secretary of State's mantle and decide whether or not somebody's exclusion is conducive to the public good?
My lady, that is a different question. And perhaps if I start by taking my lords and my lady to the case of TZ Pakistan, which is at tab 15 of the authorities bundle. We've looked at it this morning.
Sorry, where is it again?
Tab 15, page 281, and the relevant paragraph is paragraph 34, which is at page 288.
Can we just establish what the actual issue in this case was?
The issue was, again, I think it was Appendix FM. There were two cases. If we turn to paragraph 1, it sets out the background. Decisions to remove were resisted on the basis of Article 8. And there was also an issue as to whether, if the requirements of the rules are not met by an applicant, such as these, the assessment goes to an assessment outside of the rules, so that we're looking outside of the framework that has been set by the Secretary of State. Both of these appeals
what were the results of these appeals on the facts of each case? So these are both cases in which the question was whether there were exceptional circumstances. Is that right?
My lady, I'm not entirely familiar with the detailed facts.
Well, this is the problem with seizing paragraph 34 and saying that decides a legal issue for this case, when we don't really know what against what background the statement in paragraph 34 was made.
Looking at paragraph 6, the issue appeared to have been that he'd provided the wrong occupation code and therefore he didn't qualify under the rules. And the FT appears to have accepted that and he didn't qualify under the rules. And then you had to look at exceptional circumstances.
My Lord, yes, and there were two appeals. So the other appeal, the facts begin at paragraph 11, PG India. And this was, I think, a pure marriage
Right.
case.
So, discussion, paragraph 18. Well, Justice Ryder says, for simple answers to the questions originally identified in these appeals, helpfully identified blah, 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 sets out the generic facts of both cases. Neither appeal involves exceptional circumstances. To put it in a small class of cases in which leave to remain outside the rules should have been granted. Principles in Agyarko dispose of all the issues in these appeals. So that is the background against which the statement in paragraph 34 is made. And since in neither case were the requirements of the rules met, one might think that the last sentence of paragraph 34 is obiter. What do you say about that suggestion?
My lady, it might well be obiter. It is certainly, in my experience, and I don't think there's a difference between the parties on this issue, the way that the tribunal has approached the assessment of Article 8 in cases that come within the rules. The process is always that one looks at the rules, because if the rules can be satisfied, by definition, a refusal would be disproportionate, because the Secretary of State's own assessment is when you meet the rules, that is where the balance of proportionality lies. That is the Secretary of State's own assessment.
But is this the only statement in a decision of this court or higher of this principle?
I'm not sure that it's the only statement. It's the statement that is most often cited. That's certainly my experience. And I think, although we don't have the authority in the bundle, or we can certainly look at this over the lunch break.
All right.
Yes.
Again, it's not an issue.
Do we have Agyarko in the bundle?
My Lord, I think we do
yes,
have Agyarko.
it's in the supplementary
It's in
bundle.
the supplementary
Yes.
bundle.
Right. Well, we'll have a look at that as well.
Yes.
That's Supreme Court authority.
Yes.
And that's summarised in paragraph 2 of this judgment.
My Lord, yes. And it might also, if my Lords and my Lady are looking at Agyarko of the lunch break, be useful to look at paragraph 57 in relation to the exercise for the First-Tier Tribunal upon appeal.
Am I right in thinking Agyarko predated and informed Appendix FM?
Agyarko
not?
did not predate Appendix FM as far as I'm
Right,
aware.
I can't remember the timing, because for Appendix FM is, for those of us who are very ancient, a relatively new development.
Can I just check about paragraph 34? I'm having trouble. Did the rules say if it would be insurmountable for you to go abroad, we will give you leave? Or is that a description of the circumstances outside the rules, which seems to be what 34 suggests?
My Lord, the insurmountable obstacles test under the rules, I think, kicks in where the primary requirements of the rules are not met. So there is an exception built
Yes,
in.
so you've got a series of rules you've got to meet, but if you don't meet those rules, the rules say you can still get in exceptionally, but it's only going to be exceptional if if there are insurmountable
Yes.
obstacles.
And in the respondent's case, there was no issue with any other provisions of the rules. So the only issue was suitability. If there was not a suitability issue...
Yeah, and suitability, I mean, the problem is it's an assessment. If you've got to have £22,000 and they've forgotten to add in a bank account, if you've got a conviction and in fact they've mixed two people up, two people with the name Lewis, and they've got the wrong Lewis, you can see that. It's more difficult when you've got a criminal offence involving child sex offence and the Secretary of State says, this chap shouldn't be allowed in, because 23 says you've got to bear in mind the primacy in terms of immigration control or the view of the Secretary
Of course.
of State. You've got to look for something that says, this was wrong, not, I disagree with it.
My Lord, I think, and my Lords will and my Lady will look at paragraph 57 of Agyarko, and I think there is something in Hisham Ali that is also instructive on this. But I think that the line of authority as far as I've understood it, is that the assessment of proportionality is a matter for the judge. That is something that the judge must do.
Well, the
for
Supreme
himself.
Court has now emphatically said that in Schwidler. And whatever else we say, we have to follow Supreme Court law.
Yes. And I think when one looks at it from that prism, it's fairly straightforward, because it is the judge that must make that assessment, of course taking into account and placing appropriate weight on the views of the Secretary of State. But one cannot have the judge performing a judicial review function on a statutory appeal, if that is where we are sort of potentially heading. If the starting point is the Secretary of State's assessment, and then you're simply reviewing it.
No, we understand your submission. It's not a judicial review function. Right. Now, I see the time.
Yes, my lord.
Shall we adjourn there? Now, how much longer do you think you'll need?
My lord, I've only just started. In that I haven't actually started engaging with the grounds or the examination. But I would hope that if we start at 2, I shouldn't take much longer than 1.5 hours. Of course, depending on.
But I certainly will expect you to finish in that time.
I'm grateful for
Because
that
you've
indication,
had almost half an hour now.
Yes.
All right. So we look forward to seeing you again at 2 o'clock.
All right.